any feedback, that would be great. I'll go over some housekeeping, share with you the mandate of the local HSJCCs for those who are not familiar. The mandate for the local HSJCCs basically is to engage in joint sort of cross-sectional planning, coordination, and integration of services for individuals with a mental illness who are then involved or at significant risk of being involved within the criminal justice system. There are 4 locals. There's one in the West, Toronto, North York, downtown Toronto, and Scarborough. And all of us report to the Toronto Regional Committee. The 4 local HSJCCs identify local priorities and for planning coordinated services or establishing a process for planning and joint problem solving in relation to all these local priorities and issues. And each local HSJCC is responsible for working together to address the local needs and reporting to the Toronto HSJCC to sort of help inform systems planning at a regional level. And if you're interested in joining, please write your email in the box, and Dominica, who's our coordinator, she'll contact you and put you on our distribution list. Again, please mute yourself, and if you have a question, write it in the chat box. Jason will be monitoring the chat box, and if he misses a question, then I'll be sure to ask him that a little bit later. But also there'll be time at the end of the session for question and answer. If you want to type in your question and ask it later, that's fine. The session will be recorded. If anyone's uncomfortable, please let us know, and that would be great. You can put that in the chat as well. Also, Jamaica has been very kind in sharing the Survey Monkey. This is to be completed. It's an evaluation. The link will constantly appear in the chat box, so your feedback will sort of help us plan future sessions and continuously improve. It'll just take a minute to complete. So if you can please all mute yourselves, that would be great. So I think with that, we're ready to get into it. I want to tell you a little bit about Jason. So Jason Balgopal is a graduate of Osgood Hall Law School. I'm hearing a little bit of feedback.
If I can hear it in your voice a little bit. No, this makes sense.
People on the phone, if you can please mute yourselves. Okay, I'll start again. Jason Balgopal is a graduate of Osgood Hall Law School and an Ontario lawyer who was called to the bar in 1999. He has been practicing exclusively in criminal law since 2003. He has been an assistant Crown attorney in the Scarborough Crown Attorney's Office since 2004, and he has appeared at all levels of the court in Ontario and has conducted all manner of prosecutions, including murder trials and a dangerous offender application. So lots of experience there. He's a member of the Elder Abuse Consultation Team in Toronto and has presented many times on the topic of elder abuse. After a lengthy challenge with depression and after getting a better headspace for himself, he wished to give back to the community, which has supported him. And in 2015, he created the mental wellness peer support groups, which have been operating continuously since and still are during COVID, operating virtually through Zoom. And more information can be found at his website. And if Dominica's able to, if we can just post the 2 website domains in the chat, that would be great. And I think again, I'll make a request to please mute your mics. And welcome, Jason. So happy to have you. Thank you for being here.
Well, thank you very much for having me. I hope everybody can hear. I just heard a little bit of staticky feedback. Is the sound quality okay?
Yeah, I think there's a little bit of echo. People just need to mute their mics.
Well, if that's still hearing some feedback, but I can keep going if it's just me, or what I'll do is I'll change my headset in case that's what's causing the problem.
Yeah.
How do you mute this system? Excuse me for interrupting.
There's a speaker at the middle of the screen, so you just click on that.
I wasn't able to get through on the link. I had to just do a straight phone call through.
Okay. So if you have any questions, please email me.
Okay, Jason.
I'm sorry, I couldn't hear that. There's such an echo.
And I'm happy to go forward, but I do hear, things have cleared up now. All right. Samim, good? All right.
Good to
All
go.
right. Fantastic. Well, thank you very much, folks, for coming today. I appreciate the time that you've taken to come today. I, of course, as a Ministry of the Attorney General employee, want to let you know that these are my personal views, not those of the ministry. And some of the comments obviously might be specific to the Scarborough Courthouse because that's the courthouse that I know best. The talk today is about criminal justice. So not about provincial offenses like Highway Traffic Act offenses or municipal charges such as bylaw infractions. Those go to different courthouses and there is a different procedures that they will also follow. And just to let you know that the criminal courthouse never shut down completely. They can't. There are always people that are going to be coming through the system. And I do hit pause every so often because I'm getting a fair amount of feedback. I'm not sure whether it's just me, and if it is, I'll keep plowing along. But if other people are getting it, maybe we should stop. All right, I'll talk a little louder and see if we can get that through then. So what I wanted to do is talk to you about what happened before COVID hit, and then how things have changed since that time. And I'll run through the process of how the criminal justice system works from sort of the beginning to the end. The idea, I think, with any presentation is that if you get one or two things out of the presentation at the end, then it's been a good presentation. So I'll give you a secret. I'll tell you what the things that I'm hoping you're going to get out of this are. Diarize, diarize, diarize. Make sure you and your clients know what the next court date is going to be, and show up by Zoom. So that's two things, but we'll squish them into one. So the first general thing that happens in the criminal justice system is an arrest and charging. In the past, traditionally, it's been the police that do the arresting and charging. You might say, of course, that seems really obvious. How else could it be? There actually is a procedure by way an individual citizen can go to the police, can go to a justice of the peace and lay a charge. It's called a private information. And normally what happens is the person goes to the justice of the peace in the courthouse, says, listen, somebody did something bad to me. If the justice of the peace believes it is a criminal offense, they go to the next step, which is to issue, to have a pre-enquête or a hearing to determine whether or not the alleged defendant should be brought before the justice system. The police, on the other hand, do that all in one. They have that authority as police officers. They go out, they see somebody committing an offense, they receive information somebody's committed an offense, and then they arrest them and bring them before the court. The arrest process continues to happen by the police. And that, in fact, you'll ultimately see as part of this presentation is a bit of the challenge that we're facing, because if you view the criminal justice system as a continuing with stuff, people being charged coming into the system, and then ultimately trials or guilty pleas or withdrawals of charges at the end, and then being released from that system, what's happened is the police keep feeding that system because police keep believing that people are committing crimes, and they keep arresting them. And that means we've got a bit of a bulge in the python, so to speak. So what has happened since COVID hit? From the point of view of the police, not much with respect to the arresting. They continue to arrest people, obviously. Crimes are continue to be committed. And so as they do that, they will charge the person and place them before the court. The option for private charging, I haven't seen it happen. I just haven't seen anybody come because we haven't been in the courthouse and we haven't been having anybody on the pet. So readily, I can't have the information. I can only imagine that they are available, just in practice hasn't been done. The next step in the process is a bail. That happens in 2 locations. And I do apologize for the terrible sound. We need everybody to mute themselves. And once everybody is muted, then we don't get the feedback. And thanks very much. So the bail process happens in 2 fashions, as I was saying. One is the police can and often do release somebody at the scene or very shortly thereafter, having them agreeing to certain conditions. That hasn't changed. It continues to operate, and the police continue to arrest people and release them with conditions or not sometimes, but always with a future court date that they're supposed to come back on. The very challenging aspect has been the traditional bail court, where the police have arrested somebody and they may have made a determination for legal reasons that they believe they can't release the person on police forums, and they require the matter to be heard by a jurist. This is one of the functions, one of the areas in the criminal justice system which did not shut down. The bail system continued. It in fact runs 365 days a year, New Year's Day, Christmas Day, normally it happens on that fashion. And even with a pandemic, it was impossible to shut that down. People needed to get bail. But big changes happened. Initially, the government was not able to get a Zoom system running for a variety of reasons, and so bail continued with a telephone system. Officers would arrest somebody, and if it was appropriate, they could have their bail hearing very quickly, or perhaps it was going to be a consent release. Then the person would remain at the police station pending that happening. They, the defendant, with the assistance of the police, would call into the court on a telephone. If a person had been arrested some days before, had been before the court, was unable to deal with their bail matter, they would then be sent to a detention center, the Toronto East Detention Center, the Toronto South Detention Center, and they would then be able to call in again on a telephone to have their bail hearing. This is vastly different than the way bail hearings were done previously. Before COVID, people were brought in person at all bail hearings, even if they just wanted to remand their bail hearing to a future date. The advantage with the in-person bail hearing was that people could get a ready connection with their lawyers. The lawyer could come and physically see them, talk to them, have an opportunity to discuss matters, and the lawyer could then, within the courthouse, corral, so to speak, a variety of service providers. Bail program, which is a program that assists people in getting out on bail, mental health professionals to assist them, as well as getting a legal aid certificate, so the lawyer might be able to get paid. This is now all done virtually and dramatically slows down the process, because it doesn't happen that you can just walk down the hall and knock on somebody's door and talk to them. Appointments have to be made, phone calls have to be done, so that those kinds of work can be done to prepare for a bail hearing. It's recently moved, at least in Scarborough, that the bail hearings are going to be able to be done by Zoom, which is now one of the video methods that's being offered. However, the detention centers and the police stations still don't have a laptop or anything with a camera that can make that happen, and therefore the defendant calls in on audio. Again, not a preferable way of doing it, but this is what we're doing to ensure that justice gets done during the pandemic. Sometimes the effect of this has meant that bail hearings actually are quicker, are more speedily done, in as much that a surety, somebody coming forward to pledge a certain amount of money to help get a defendant out and supervise them, often does not experience the cross-examination by the Crown Attorney that was done before, to probe and determine whether or not that person is an appropriate surety or not. Certainly checks are done to ensure that the potential sureties have no criminal record or no criminal past, but it's very difficult sometimes to divine deeper and see what the person is or is not about, because we don't have that ability to cross-examine them. We do somewhat, but it is limited. Once the person has received a bail, if they do, the next step, well, I should say, whether they get bail or not, the next step is going to be getting disclosure. If a person is detained in custody, then obviously we try our best to ensure that the process moves as quickly as possible. But in either case, the next step is going to be getting disclosure. Disclosure is a copy of the evidence that the police have gathered about the case and is provided to the defendants. It could be copies of witness statements. It could be copies of videos, surveillance videos, or even some of the videos that the police capture themselves on their vehicles. They have in-car cameras, and they will also capture evidence with respect to that. In the past, even as recently as about 2-3 years ago, all of that disclosure was primarily provided by way of paper. Obviously not the videos, but all of the notes, etc., was provided by paper. In the last number of years, that has transformed into an electronic system where that was provided by DVDs. The Crown Attorney's Office would burn a DVD, and that would be given to counsel or the defendant, and then they'd have to go and they could look at it how they wished. In order to stop the transmission of COVID and have people not come into the courthouse, the primary method now is to do it electronically. There is an electronic disclosure hub, and the disclosure is then provided to counsel, directly to counsel as they wish, or if it's a defendant, in a two-stage process. The defendant will have to give us their email address, and then once the email address has been given, We will send them an undertaking that they promise to only use it for this purpose and not disseminate it. And then we will, once receive that undertaking back, send them electronically the disclosure. The benefits to this are actually that we can, from the Crown's point of view, ensure quite more accurately who has gotten the disclosure and that it has been sent out in a timely fashion, and that people can receive it very directly. They don't need a DVD reader or anything like that. They can just go onto the website, download it. Obviously, the downside to that, or the challenge for that, we find is anybody who's in custody. That's a challenge to get that disclosure, but we do find a way of doing it. And also people who don't have access to a computer system. And there are a number of people who don't have that access, but the system does allow at least them to use a cell phone, whereas if you had a DVD in the past, that was more challenging to use that with a cell phone. Just get my speaking notes here so I know what I'm talking about. After the disclosure process comes the retainer process, and that's the time when a defendant would find a lawyer and get a lawyer involved. Before the pandemic, this was often a very organic process. Defendants would be in the courtroom or the courthouse halls. They'd see somebody they thought would be a good lawyer for them, and they'd strike up a conversation, have a retainer with that person. They could also go and talk directly with legal aid. Legal aid is a government program, obviously, which assists people who are marginal in their funding abilities to be able to get a lawyer to help them. There are also clinics, student clinics, and a variety of other legal clinics that offer legal services to help people. A lot of those people were physically in the courthouse, and defendants could more readily find them, track them down, and get a hold of them. So it's a lot more challenging for defendants now to find somebody to represent them. And obviously that's all done virtually by computers. The clinics, legal aid, all still running. But instead of actually going in person to see them, the connections have to be made by telephone or, in fact, by computer. Normally in that process, when that retainer is happening, if a lawyer has been retained and they are able to get a client to sign a designation. Now, a designation is a document which allows the defendant to say, listen, that's my lawyer. They are fully retained. At law, because I've signed this designation, I, the defendant, don't need to appear. My lawyer will go on my behalf. It's a way of allowing defendants not to have to physically trudge to the courthouse if they have a retained lawyer who can go on their behalf. That has been in existence for many years and is codified in the criminal code. What the Chief Justice did when the pandemic struck was to create an understanding of enhanced designations, which in essence allowed defendants to say, that's my lawyer, I want that lawyer to appear for me. The lawyer then to send into the court a document saying, I am the lawyer for this person, I have been retained, and I'm going to receive the disclosure, I am going to review it, I'm going to have a pretrial with the Crown, and then a judicial pretrial, and then we will ultimately resolve this or set a date for trial. And I will do that within the next up to 12 weeks. And the enhanced designation allowed the defense counsel just to place a document before the court, the enhanced designation, and have the matter go over for up to 12 weeks, so 3 months, and in that time period, do a variety of activities that are required. You might say to yourself, well, 3 months sounds like an awfully long period of time. And I would say so too, especially when you have to consider that one of the protections that people are given in the Charter of Rights and Freedoms is the right to have their trial held within a reasonable time. Section 11B of the Charter of Rights and Freedoms grants that to defendants, and obviously there's a bit of a balancing that's happening now between a pandemic which says slow everything down so that we don't get people infected, and charter rights which say you got to keep moving, you got to have these trials done in a reasonable time. A lot of the view has been that the pandemic is a discrete event and would exempt that time period during that pandemic from the calculation of how long it's been to get the matter to trial. But all sides have to act consistently and I don't want to use the word aggressively, but they have to act with diligence to ensure the matter is being moved forward even during the pandemic. So the enhanced designations are an interesting juxtaposition to that normal procedure of having things move more quickly by allowing the matter to go over for a lengthier period of time. When the process of moving matters along is done at the set date court. Set date court is one where traditionally we have had, quote, the masses show up. Many defendants will attend, and when the defendants attend, we deal with lawyers first, and then defendants are dealt with later on, which practically meant you'd have in our set date court, not unreasonably, 15 lawyers at the bar waiting for their matters to be heard, and 45 or 50 people sitting in court waiting for their matter to be heard. Some of those people were being dealt with by the lawyer at the bar, and some were waiting for their matter to be called because they had no lawyer, which interestingly meant that a lot of people were spending a lot of time physically standing around or sitting around in court. Work was being done, we were very efficient, but it still took a while to get to everybody's matter. So what initially happened when the pandemic hit was the set date system, nothing can stop, but they told everybody not to come to court. And the court system, under the auspices of the Chief Justice, used what is called a discretionary bench warrant to legally remand people. A bench warrant is a warrant for the arrest of somebody, and it's issued by the jurist who's presiding that day. Normally, it's issued if somebody doesn't appear for court. So if somebody doesn't show up for court normally, then the justice would issue a bench warrant, which would tell the police to go and arrest them and bring them back before the court. A discretionary bench warrant is a provision in the criminal code which does the same thing, is an order of the court saying to police, go and arrest the person, but you are told that the court has issued the discretion not to execute it until ... a future date. So, how has this worked in the past? In the past, we may have received some information, oh, the defendant just got hit in a car accident. They're going to be in the hospital for another week. They can't come to court now. Please just adjourn the matter 2 weeks. They'll be better and on their feet then. All right, we'll issue a discretionary bench warrant for 2 weeks. And then as long as the person shows up in 2 weeks, no harm, no foul, the discretionary bench warrant is rescinded and the matter keeps going on. If after 2 weeks that a person didn't show up, further decision is made, should another discretionary bench warrant be issued to a future date, or should it turn into a straight bench warrant and police go out and arrest the person? So what the Chief Justice did was they implemented rolling discretionary bench warrants. Everybody that was in the set date system was automatically given a discretionary bench warrant. And that just kept the legal process alive, so to speak, and push the matters further down the road. So from March of 2020, those discretionary bench warrants started coming into effect, and they continued right through until closer to the end of the summer. And it was only towards the end of the summer that, having dealt with the other areas of the criminal justice system, which were most important to be dealt with, including the bail system, the plea system, they were able to focus on the set date system. And it was at that point then, towards the end of the summer, when the levels of the COVID were going down and the restrictions were being lifted, that we were able to get a return to some normalcy. And that in the set date system meant that people were able to call in. Initially, that was very challenging because the documents given out often look to many defendants like they should be calling in on a telephone. And just on this presentation we're doing now, every so often somebody has accidentally left themselves off of mute and you can hear what's happening in the background. Imagine you have people who aren't quite so diligent, who are calling in on the telephone. Hello, I want my matter heard. I've been on for 10 minutes, half an hour, 3 hours. A lot of very frustrated people. And so at least in the Scarborough courthouse, one of the things we did, well, actually, I did, was fairly instrumental in dealing with it, was to move to a new system. We utilized the Zoom system, and in doing so, we ended up with sort of 2 rooms. effectively a hallway outside of court, and then the courtroom itself. And in the hallway, we gathered information from the people. When the person would call in on a phone line, you'd only have telephone numbers showing on the screen. We couldn't even see who they were. So we used that hallway as an option to learn who the person was, remind them that they had to be quiet, learn what they wanted to do in court, and then send them into the court. This two-stage process became very efficient, and it moved our, at least in Scarborough, our system along much faster. And so now people are calling in by telephone still, but more and more people are calling in by Zoom, using the video Zoom product. And that aids us greatly, because with the video product, with the Zoom, see, look at that. My phone went off on a ding and I interrupted you, and I apologize for that. With the video product, we're able to get people to have more communication, because communication is certainly auditory communication. I can speak to you, but it's also visual. What do you see happening with the other person? And we're able to get faster and better communication between the people, find out what they want to do when they're able to use the Zoom system by video. And they're also able to rename themselves so that we know exactly who they are, as opposed to just saying on Zoom, you can put whatever name you want, Jones or something like that. And we'll actually have them rename themselves so we know which docket or line number they're appearing on. This has actually made the pandemic aspect of the set date system go much more quickly. But again, as with all of the things in the pandemic, it's become very challenging because people aren't able to go directly during that set date system, set date time to the service providers. The Salvation Army, mental health, legal aid, bail program. It means people will have to be checking in. Instead of coming to the courthouse one time and checking in, they'll have to check in on a variety of different platforms. Zoom for the court, a telephone for their bail program, and then calling in to try and get legal aid. Much more challenging. Now, again, if you're taking away anything from this and you're talking to your clients, definitely tell them to go and use the video product from Zoom. Don't just call in on a phone. They can, if they want, use their cell phone, but make sure that they actually use a video so that we can see their face. It'll get them through the system faster. On average now, our lawyers are able to get in and out of the set date system in about half an hour. And if defendants call in when they're told, not when they think about they want to, but when they're told to call in, they're in and out faster than an hour. I would say within about 45 minutes, most defendants. Now, what happens if they don't appear? Just like in the olden days, pre-COVID, if a defendant doesn't appear, the court has to do something. They can do one of three things now. Issue a bench warrant, which is go and arrest the person. Issue a discretionary bench warrant, go and arrest the person, but don't do it right now. Let's see, we'll give them a week. If they don't come back in a week, then you can go and arrest them, or issue a bench summons. All three of these are being used in varying degrees. The more information we have about a person of why they may not be attending court gives more information to the jurist to allow them to make a decision to issue a discretionary bench warrant. Oh, the person was hit in a car accident. They're in hospital. Well, we don't want to go and arrest them for that. That's not fair. So let's get them a discretionary bench warrant, and hopefully they'll come back next week. Hopefully. That's the other aspect of this. Use the video Zoom and diarize or communicate. Find out when your next court date is. The Crown is generally not reaching out to defendants to let them know, hey, you missed your court date, come back to court. That's a defendant's responsibility. And so if a defendant is in a terrible car accident, or they're in hospital and they can't get to court, they still have that obligation to find out when their next court date is. And the more information they're able to provide, the better and easier it is for us as justice system participants to help them. If we have no information about them, the defendant has not been attending court in a while, if there's no way that we can get a message to them, they don't have counsel, then we are limited in the number of options we have. And so one of the options may be to issue a bench summons. And a bench summons is an order of the court saying, come back to court. It is an order that the court issues and requires police to go and serve. And so that means that the police officer has to go and find the person and give them a piece of paper and tell them you've got to come back to court. That obviously poses its own challenges because it consumes the time of police officers to go and serve a document when they could be out patrolling for prevention of crime. and also necessarily engages a bit of a face-to-face communication when the person is given the piece of paper. So that leaves the third option as a viable option, which is that straight bench warrant, which is police officers, the person has not attended court in a while, go and arrest them and bring them to court. Now, even with that, we have found ways of attenuating the serious consequences of being arrested. Once a bench warrant is issued, the police will then make an attempt to contact the person and say, hey, there is a bench warrant for you. If you come back on this specific Monday, then we will have that bench warrant before the court. You show up before the court, and they will deem the bench warrant to have been executed. You don't actually have to be arrested. But if the person doesn't come up, then the police will go out and arrest them. Once the set date process is finished, there are sort of two next types of steps, Crown pretrials and judicial pretrials. A pretrial is just effectively a discussion. And some of the best times I have, quite frankly, are in Crown pretrials. It's an opportunity for me as a Crown to have a discussion with a defense lawyer about what's going on with the case and what's happening. Those, quite frankly, haven't changed in a great deal. Traditionally, the Crown pretrial would be scheduled with a defense lawyer. We would often have it in one of a couple ways. You know, by telephone was very, very traditional, but also in person. Defense lawyer would come to the office and we'd have an opportunity to chat. We still do the pretrials now, and they are done by phone. The downside, obviously, is we're not able to easily exchange documents or see what the other is pointing to. Oh, look, this person got this kind of mark on their test. We should give them some sort of benefit for that. You can't easily see that. The other aspect that is challenging is, in Scarborough at least, we used to have a pretrial office. Those of you who are familiar with the Scarborough Crown Attorney's Office, you'll know it's called the Cave. There's a fun way of referring to the pretrial office. And it was a very communal and enjoyable experience because we got to see a lot of private counsel or duty counsel lawyers and come in and discuss a variety of cases that were up that day. So even if a matter didn't have a pretrial scheduled, but the defendant says, listen, I think I want to resolve this now. I want to find out what the Crown's position is. That resolution meeting could happen immediately. And that has taken a bit of a back seat now because we don't have, generally speaking, that availability. We are trying to build it in, and we have made a number of efforts to do that. In fact, in Scarborough, in the set date process, once somebody has zoomed into that hallway I talked about before they get into the court, there's an option to get into a pretrial office where a Crown is there. And so if a person has a matter up today and they zoom in, they would have an option to speak with a Crown attorney and a duty counsel lawyer who's there to staff as well, which is fantastic. And I think we're one of the fewer courthouses that have that as an option. But to talk about something that may not be up today, may be up in a few days, and counsel just wants to, hey, I'm in the courthouse. I'm talking about another matter. I want to see if I can solve this other matter as well. That's not happening as much, and that's a bit of a challenge. After a Crown pretrial happens, where perhaps an agreement is made about a resolution, or perhaps not, the next option often is a judicial pretrial. And at a judicial pretrial, the defense lawyer and the Crown attorney are both present, but also the judges. And not much has changed there, except that, again, it's not in person. Adds a little bit of a challenge, but it's not the end of the world. Two big areas where things have changed quite dramatically are on the back end: the guilty plea process and the trial process. The guilty plea process is where a defendant has decided that they wish to acknowledge wrongdoing and go before a judge and admit that. At the pretrial stage, the Crown pretrial or the judicial pretrial, a determination is made as to what the appropriate penalty might be or what various counsel, the Crown or the defense, may be asking the judge. And in the days pre-COVID, people were able to go very quickly into having a guilty plea. Strike while the iron's hot. The defendant wants to have it today. The defendant can go right in. Now, things have to be scheduled. Up until about a month or so ago, 2 months ago, any guilty pleas had to be scheduled through the trial coordinator unless it was somebody who was in custody, and the position for them would have been, I'm going to be able to get out right away. And so that meant it often delayed the person being able to get to plead guilty until that could be scheduled with the trial coordinator. Most recently, they've been able to open that up. And now people are able to plead guilty on their appearance date, and that's been able to make things go much more quickly. If there is counsel involved, the person can use a telephone and just call in without a video product. But if not, generally speaking, they should be calling in with a video product. Lastly, as far as the big things to think about are trials. And that has had the COVID has had a huge impact on trials and trial management. Initially, obviously, trials were all done in person. Up until beginning of July, no trials were done at all. The trial just stopped, by and large. In July, trials opened up, and I did a trial in the courthouse in July, and it's just a sea of plexiglass, and everybody wearing masks. And shortly thereafter, into the early autumn, the court system opened up Zoom for doing trials, and now a vast majority of the trials are done by Zoom, or the preliminary hearings are done by Zoom. Obviously, this actually ends up in a benefit to a lot of witnesses, in as much that they can testify from a location where they don't have to come into contact with people with COVID, and they can also testify at a location where they may feel more safe and secure. Lastly, it also allows people to be able to testify from remote locations. So if a witness is in a different city or a different province, that doesn't pose a problem on a Zoom trial. What it does do is it does mean with COVID that we right now are not able to have jury trials. And those are something which are a mainstay of the court criminal justice process, and those have been closed down. They, at various times during the COVID system, they were closed down and opened up and closed down and opened up as the respective health officers have determined it appropriate or not. What this will mean in effect is there's going to be a bit of a bubble, as I talked about, that bulge going through the python, as people have spoken about in the past. And we are having a lot more cases now. I have about twice as many cases on my roster of cases than I did for the years before COVID struck. And it's not that fewer cases are coming in, it's fewer cases are going out of the system. They continue to go out by way of guilty pleas, and Crown's reviewing files and saying this is not appropriate to have go through the criminal justice system. We will divert a matter, or if it's a completely inappropriate charge, withdraw it. But for those matters where there is no availability of either guilty plea or withdrawal, then it has to be for a trial. And in that case, things are slowing down significantly. For your clients who may be in the criminal justice system, but also might be witnesses or victims, they should be aware to expect a virtual trial that is by video. So they should be preparing themselves to get a quiet location think about the backdrop. What is the judge going to see behind them? Is it going to be something inappropriate? As well, they should also consider what kind of video bandwidth they have. Do they have this ability to stay online for a couple hours while they testify, or are they going to eat up all their data? So a good Wi-Fi system will be useful for them. They should also know that while the video trials right now are by and large what's happening, defense can certainly ask for and can obtain the requirement to have a physical in-person trial. It ultimately is up to the judge to determine what form the trial will take. And sometimes we won't know that determination until about 2 weeks before the trial date. There's a confirmation hearing 2 weeks before, and at that time, a decision should be made by a jurist as to whether this is going to be by video or in person. The people that witnesses or victims should get in contact with to find out about this are the police, because they are the first and important line of communication with defendants. So what does that leave you with? If you listen to all of this, that it's important for clients to diarize and know their next court dates, whether they are a witness or whether they're a defendant, and that they also should try as hard as possible to use the Zoom video system so that they are able to get in and out of court as quickly as possible. I think that's really all I wanted to give you as information. That gives you a sense, I hope, of how the criminal justice system both works as sort of a process and what the differences were before and after. And I think then the only comment I'd make sort of to finishing off my presentation would just be, this has been a terribly challenging process in the criminal justice system. This is something that has obviously caught all of us off guard, but I would say I'm surprised at how much we've risen to the challenge, and the colleagues of mine that are doing the work in this system are working far harder than we have before. I would desperately love to go back to 15, 16, 18 months ago, because life was a lot easier for us. So I can certainly imagine that all of your clients are feeling the same kind of stress. And I thank you for listening, and I'd be more than happy to answer any of your questions. I may have missed them if they were up in the chat. I'm sure Samim will let me know if I have missed any of them, but thank you very much for listening.
Thank you, Jason. This is really good. At one point, we had more than 100 people, so definitely the interest is there. So I think the questions are coming in if you want to check your chat. And yeah.
So question is, what changes do I anticipate post-COVID? Personally, and again, this is all my personal view, is I would imagine that the video products are going to be used more and more. I would imagine both for bail, for set date, and even possibly for trials, although that will be more curtailed. I think wider spread use of video for set dates and bails will be something that we're going to find ourselves doing. Question was, are we going to transition to the Zoom platform, and will that be in lieu of JVN? So the information that I've got for our local courthouse is, for bails, we've been moving from a telephone-only system to Zoom. I don't know if there are going to be any other platforms used. That is above my pay grade. Now, another question is, why are people moved from one detention to another while waiting? So this, again, is not within my purview, within the Ministry of the Attorney General. It's the Solicitor General's purview. But my understanding is they move them for a variety of reasons. Certainly, safety is one. Sometimes certain people can't get along with others. Certainly, it will also be for safety with respect to COVID. Balancing out the number of people in an institution. If you have too many in one, you have to move them to another location, and therefore that sometimes necessitates a move. It also can be that they will move somebody to be, I should say, in the past, they might move somebody to be closer to the physical courthouse where somebody was. Because if somebody were to have a bail hearing in the past, they would physically come to the courthouse. And if the person were in Lindsay, that's a bit of a jaunt to come down in the back of a van, paddy wagon, so to speak, to have their bail hearing. So they might move them a night or two before to a local detention center. Next question asked is, if jury trials are being delayed, does that justify Section 11B being waived? So Section 11B is the section of the Charter of Rights and Freedoms which grants defendants the right to have their trial held within a timely fashion. It also is of benefit to victims and all people in the criminal justice system, because to have timely trials is better for everyone. When jury trials are delayed, does that justify 11B being waived? A defense lawyer traditionally will make a decision as to whether they wish to waive their client's rights under 11B to have the trial held in a timely fashion. And usually that's done for a specified time period. So for instance, let's say a defendant has said, a defense counsel has said, listen, I think my client has some medical evidence which may change your view of this case. Or I want to get another witness's account of this. I know, Crown, you're ready to go forward with the trial and set it for some weeks from now, but I think I can get another witness who can give you shed light on this, and you should really hear this. It's at that point a defense lawyer might reasonably say, for that period from today's date until I come back to you and say that I've got this witness's testimony, I'm going to waive 11B. Might be a couple weeks, might be a month, something like that. And so it's the defense lawyer who ultimately will decide whether they wish to or not waive 11B. And so they don't generally waive 11B for the whole time period. I hope that answers the question. All right, so how do various courthouses manage clients who don't have access to a phone or computer, such as the homeless? So right now, we want to make it as inclusive as possible that people can get their access to justice. If they don't have a video product, absolutely a telephone can be used. Whether it's a cell phone or whether it's one quarter into a payphone, we want to be able to have them be able to come in. We have had occasions where people have not had any access to that and have presented themselves to the courthouse. And that's where the best relaying of information helps us help them. If they're able to provide information to the officers at the front and say, this is the reason I'm here, I can't get in, I can't use Zoom, I can't use a telephone, then the officers may let the person in so they're able to get in, talk to the Crown Attorney's office, and that message then can be relayed. Mr. Jones is here at the desk, at the window. He wants to have his matter go over 5 days, and then there's an example of when a discretionary bench warrant may be used because Mr. Jones can't himself be physically in court or on audio. We will issue this procedural mechanism to have the matter go forward without impinging on him. It must say, it is a very challenging thing for people who are homeless. In Scarborough, we don't have the same type of homeless population that some other areas do have, although we obviously, sadly, do have a homeless population. Next question. Do you feel that social services for victims and the accused have been affected by the pandemic? And if so, do you have suggestions to assist with those services? So I really can't comment on whether the social services have been affected. What I can say is that the connection to them has been affected. Social services such as mental health supports in the courthouse, victim witness assistance program that helps witnesses and victims, a bail program, legal aid, the Salvation Army, diversion, also known as Springboard. Those have all been greatly affected because the traditional method of communication with those agencies has been in person. All of those agencies, to my knowledge now, are dealing with their clients by telephone, email, or some of them even Zoom products as well. So has it been affected? Absolutely. What do I suggest to assist with those services? I would say communication, communication, communication. The more your clients can reach out to the services, the more they'll want to reach out to your client. Everybody is working very hard to ensure that people have as much access as possible as they've had in the past. And so, as I said before, we're all working a lot harder, but they're trying to do it because they want to help people. So reach out, have your clients reach out. If most of them have outgoing messages on their old telephone lines to let you know what the new phone number is, if it's changed, or when they'll get back. Some have messages saying, leave a message and we'll get back to you, because some are just overwhelmed with the amount of messages coming in and they have to take a time to be able to get back to the person. All right, next question. Has your court been able to incorporate court support programs such as the CMHA, the John Howard Society, etc.? So those services, mental health services or other services, bail program, etc., are often linked in with the defendant through duty counsel. And I say often because unless a defendant has a lawyer initially when they've been arrested and are at a bail stage or at the set date stage, then at the bail stage, duty counsel is often the first point of contact where a person may have with a lawyer. And duty counsel is very good at getting people connected with the various services to assist them. And so they will be able to connect them with the various support services. If they don't, if the person doesn't have the ability to connect with duty counsel and they have a private lawyer, the private lawyers are also able to help them out as well. And lastly, defendants are able to contact most of these services directly themselves and can get help from them. Additionally, there are other services that I may not have mentioned. Obviously, Aboriginal Legal Services is an important component. We have a regular Gladue court that has happened in Scarborough. It started a couple years ago. And our Aboriginal Legal Services worker, Sue McLennan, is a very active part in our courthouse, and they also provide assistance through their services and both through the various processes, but also through the diversion process. One of the questions is just, I think, more of a comment about how some of the agencies have a limited number of slots available. And we have some other comments that mental health court support programs at various other courthouses are still available as well. So, well, that looks like all the questions that seem to have popped up. Samim, if you have anything more direct, I'm happy to answer that.
I don't, but I think you've had a lot of questions and you've done a really good job. Maybe there's one from Jackie. Maybe you want to read that, Jason?
Sure. Yeah, just looks like trying to figure out an acronym here, SSM. It looks like in other courthouses, the John Howard Society and the Canadian Mental Health Association have been actively attending their virtual courts, and they are very, very busy as well. The Old City Hall and the College Park program, they're still doing. They still have their mental health court support people assisting with the bail planning, the release planning, and diversion. But they agree that the homelessness aspect is a challenge. And thank you very much. Obviously, we're talking about earlier about Sault Ste. Marie, and their John Howard Society and Canadian Mental Health Association have been active in their courts as well. Okay. Well,
That seems to be it for the questions. Well, you've got lots of questions and you talk fast enough and you're very articulate. So you got through a lot of questions. So this is really great, Jason. Thank you so much. It was very informative and very timely. And I think we'll have you back next year to see how things have changed post-COVID, and I'm sure they will. Thank you also, everyone, for attending. We had so many people attend. Please remember to fill out the survey. It only takes a minute, and it's the best way that we can improve our sessions and provide information to you that you need. So we're here to help you. Please fill out the survey. With that, I'll say again, Jason, thank you so much. This was really, really great. And thank you, Dominica, as well, for coordinating the session. Thank you so much, and have a good afternoon, everybody, and be well and be safe.
Thank you for having me on, and thank you for listening, everyone.
Jason, you can see all the things.
That's nice. It's lovely.
That was so informative. Thank you so much.
Oh, I'm glad. I'm glad you liked it. I wasn't sure.
No, it was really like I don't work in the justice system, so it was very, very informative.
Very informative, very algorithmic. You could actually follow, like if you're not, like Dominica said, if you're not working in the system, you could actually follow. You were very methodical, and
good.
I thought it was really, really helpful for people to understand what's going on, what are the changes, and what are the possibilities for their clients. Because I mean, some of the things I didn't know about Zoom, like you made this arrangement for Zoom. It's almost like the left hand talking to the right hand, and I thought that was pretty creative. So
no, actually, I'm quite proud of that. That was quite a system we got going.
Yeah, I'm actually more familiar with Zoom. I don't really know Microsoft. I'm more familiar. So the break rooms are really, really amazing.
Yes.
To do that, whereas you can't do that on Microsoft Teams. So and Zoom is known to be more interactive and user friendly.
Yeah, no, the system we've got working now, I think it works quite well. If lawyers call in and they follow, we have quite a lot of instruction. Actually, I've created a like video and PowerPoint presentations to teach other courthouses how to do the system that we've got. And so you can send them a package and they can go and do it themselves. And it changed the set date system from running from about 8:30 in the morning till 8:30 at night to run from 8:30 in the morning till about 4:30 at night.
Oh, wow.
Yeah, it was significant. People were just going crazy.
Yeah, that's significant. Have you had any Zoom hacks?
You mean like people jumping in and, we haven't. I think, I mean, by and large, there is a password, so you have to have the link either to get in. You can't just type in the codes and show up there. That's the biggest problem with Zoom bombers is they'll just try a link, it works. And if you don't have the password, they get right in. But with these, they have a password. And so if you've got the link, you could do that. But you're not going to do too much because you get into this hallway ahead of time before you get into court. So you're not going to disturb the court. And so that's been really effective.
Because I know with Zoom, for mental health organizations, the Ministry of Health has a HIP compliant version, which if you're going to be doing any kind of clinical work or one-on-one, it has to be the HIP compliant version to address the security issues.
Yeah, no, absolutely. And I think that was one of the concerns that they had initially, and that's why everything was being done by telephone. But they've accepted that this is a reasonable balance, because one of the differences between health issues and the court is we're an open process.
Right.
Everybody's supposed to be able to come and see what happens in court. There aren't secrets about what happens in court, so we don't need to necessarily worry about that. If we get an extra person, and we have people observing. I'd say actually we have more people observing now, and I don't know whether they're observing just to see how we're handling the process, or if they actually just want to see what's going on in court. But I think we're getting more people watching now than we did before, because who wanted to walk into a courthouse and sit around